herself was a victim and is the kind of person that we work with in the Attorney General's office every day to make sure that they know their rights and that they have available to them all the support that we can provide and that we can make available in the state of Ohio. Joanna?
My name is Jenna Roscoe. I live in Cleveland and I'm 20 years old. When I was 14, I lost both of my parents. And when I was 18, my former boyfriend, Mom Reese, shot me in the face with a sawed-off shotgun. A few weeks before the shooting, Mom raped me at gunpoint. I reported the rape and he was arrested. He was released from juvenile after like 4 days after that. No one told me he was back in the streets, but I knew. I knew because he kept calling me, stalking me, and threatening me. He wouldn't leave me alone. I called the police and I tried to get a restraining order, but they told me that it wasn't possible because homeless to juvenile and the law does not allow restraining orders for juveniles. 18 days after I reported the rape, Juan hunted me down and shot me. The system did not and could not protect me. In the last legislative session, State Representative Edna Brown introduced a bill to give court-ordered protections to juveniles who face the same threats of violence as I once faced. I was thrilled when the bill passed the House, but I was devastated when it died in the Senate. The day the bill died was one of the worst days of my life. Almost as painful as the death of my parents, the rape by the guy I once was, and the shooting that destroyed part of my face. But today I'm filled with hope. Representative Brown reintroduced her bill, and it has company. Representative Sandra Harwood was a separate bill that calls for schools to teach dating violence prevention in health classes. Thanks to the hard work and support from Attorney General Richard Cordray, a larger, louder, and stronger coalition is pushing for final passage of these bills. There are a lot of teenagers who find themselves in violent, dangerous relationships. These bills are for them. It's too late for me. But it's not too late to educate young people on how to best deal with violent relationships. And it's not too late to give the justice system the tools it needs to give juveniles the same protection as adults. Thank you.
At this point, any of us would be happy to take questions.
Attorney General Cordray, how or any of our legislators, how do we put teeth into having that kind of protection for juveniles? Because a lot of domestic violence victims will say, well, I have a restraining order on my husband or whoever it might be, and they still got to me. How do we ensure that this law has teeth so indeed kids like Joanna are protected?
I don't know that any law, John, is perfect or can protect everyone against everything, but the fact that there isn't even the possibility of getting a civil restraining order when the potential perpetrator is 17, 16, 17, and very capable of being mobile at that point and engaging in a pattern of stalking a potential victim, that we think is a gap in the law that needs to be filled. And Representative Harwood's approach of making sure that this is something that is raised and that there's awareness of it among all young people, all high school students, both to try to discourage people from engaging in this activity and also to let people know how they can help and support one another and avoid it from happening. We just think that that's common sense and it would be good for people in the state of Ohio. Will it prevent all such crimes? No, nothing does. But will it help? We feel certain that it will.
Attorney General, one reason this bill died in the Senate, some senators had questions about it. Senator Tim Grandel was one of them. He insists that the current law does allow juveniles, just like anybody else, to go to a common pleas court and get a restraining order against a juvenile suspect. Is that true or not?
You know, I'm not entirely clear whether it might be plausible or possible under the law. We know that in this instance it didn't work, and we think that there's some likelihood of disagreement and gray area between the common police courts and the juvenile courts, as there have been in other areas of the law, quite separate from civil protection orders. We think the best approach is to clarify the law and speak directly to it and give juvenile courts, which we think are probably the primary jurisdiction and forum, for people under the age of 18 the authority to address this.
Is there any way you just couldn't just amend the old law to say, well, to make it clear that juveniles can go to the common police court like anybody else? In other words, what's so special about the juvenile court handling this?
Well, I think that we can talk about those things, and I'd be happy to work with Senator Rendell. We're working very effectively with him, for example, on the veteran service bonus right now, and see if we can talk through those kind of concerns and those kind of approaches. But what we'd like to see, the core of what we'd like to see, is that even people under the age of 18, there are going to be situations where they should be protected with the, in effect, an anti-stalking order. For myself, whether it's a juvenile court or a common police court, we could work on that. I know that Representative Brown has proposed to be juvenile court, and I believe she has her reasons. She's not here to speak to it today. I don't know if any of the others want to speak to it, but the bottom line is we need the protection somewhere in Ohio law, and we don't think it's clearly provided now.
Certainly. I'll tell you, this bill is a bill in progress. It's probably had 3 or 4 drafts, and we've worked with the Judicial College and worked with the Supreme Court's Committee on Domestic Violence, and that it was thought, when we talked with the judges, what was the best vehicle, and it would be because of juveniles and juvenile victims, juvenile perpetrators that have belonged in front of the juvenile court. There was a lot of question about jurisdiction, and that is why this bill reads the way it does. It's my understanding there are also 30 other states that have already passed legislation like this, with the jurisdiction being in the juvenile courts, because we're talking about juvenile offenders and juvenile perpetrators. There are just as many people that believe that the Court of Common Pleas does not have jurisdiction. And all it takes is the judge who's got the child before it to say they don't believe they have jurisdiction. It's a good reason to clarify